Hello, my name is Olivia Fowler. My class expert assignment is about the Equal Employment Opportunity Commission versus Abercrombie and Fitch stores case. This was a case that was decided in 2015. The case started all the way back in 2008. In 2008, a 17-year-old girl named Samantha Illoff, who was a practicing Muslim, wore a headscarf to an interview for a position at an Abercrombie and Fitch store. The headscarf was worn in accordance with her religious practices, but she did not explicitly bring this up to her interviewer. She didn't refer to her headscarf at all, let alone that it was worn for religious reasons. Her interviewer noted the headscarf and believed that it violated the Abercrombie and Fitch look policy. The company basically had an overarching dress code that applied to all their locations in order to sort of control and unify the aesthetics of the store. It was a very aesthetic-based store. The CEO, Mike Jeffries of Abercrombie and Fitch, was very open about the brand being meant for rich, fit, white kids. Very openly comfortable saying that kind of thing out loud. And basically part of their look policy was a clause that designated no caps. That's the terminology used, no caps. And Samantha's interviewer believed that her headscarf violated that policy. She ended up taking this issue to the district manager for Abercrombie and Fitch, and the district manager affirmed her concerns and said, no, we cannot hire this applicant because her headscarf would in fact violate our look policy. The EEOC believed that this decision violated Title VII of the Civil Rights Act of 1964. Title VII prohibits employers from refusing to hire applicants because they require religious accommodations when providing the accommodation would cause no undue stress to the business. So when it was taken to court, the district court sided with the EEOC. They were saying that Abercrombie needed to allow the accommodations, provide the accommodations, and that they could not hire her just because of the headscarf. The 10th Circuit Court reversed the decision and said that under the pretense that the employer, they couldn't be held liable for discrimination against religious accommodations when no religious accommodation had been formally requested by the employee. So they were saying that since Samantha didn't explicitly state that her headscarf was worn because of religious accommodations, that not hiring her because of the headscarf could not be considered religious discrimination. The Supreme Court then reversed the ruling and said that religious affiliations actually cannot be considered at all during the hiring process, whether or not they're explicitly stated to the employer, since the decision was applicable to her wearing a headscarf. The Supreme Court decided that it did in fact violate Title VII. So Justice Scalia delivered the 7-2 majority opinion that held Abercrombie liable. Justice Alito wrote a concurring opinion. He furthered that while the applicant does not have to notify the employer of the accommodation, the employer must have knowledge of the accommodation to be held reasonably liable. So he was saying, even though she didn't tell them explicitly about the accommodation, they did have reasonable knowledge that she would need an accommodation. Justice Thomas wrote an opinion that concurred in part, dissented in part. He dissented and held that a neutral dress code policy, which does not explicitly apply to religious dressage, cannot be considered religious disparate treatment for being upheld. So he was saying the dress code policy doesn't say no religious head dressings. He's saying since it only says head dressings in general, it's not a religious discrimination. He also said or held that Title VII doesn't designate failure to accommodate as intentional discrimination anyway. Justice Thomas. A couple of similar cases that this made me think of. Immediately, the Toyota Motor Manufacturing in Kentucky Incorporated versus Williams. The Supreme Court determined that the circuit courts, like Abercrombie, had not applied proper standard about the applicability of employees to legislation. In difference, though, the Toyota ruling was that the employee did not qualify under the current American with Disabilities Act, unlike the Abercrombie ruling, which stated that the employee did qualify for discrimination. But the Toyota decision was eventually overturned after amendments were made to the ADA anyway. But then another case that I thought of was the Harris versus the Forklift Systems Incorporated. That one is just directly about Title VII from the Civil Rights Act of 1964. Abercrombie used Title VII to conclude that the harm of religious discrimination in the workplace outweighs any detriment that religious accommodations would cause to the business. And the forklift system case ruled that Title VII says that the harm caused by sex-based discrimination in the workplace outweighs any detriment to the business that they would face for eradicating such behaviors or discriminatory language. Essentially, all of these cases I felt dealt with the general concept of undue harm to businesses and employees. So a couple of the individuals involved, this is Samantha Aloff. She is the one who was denied a position at Abercrombie & Fitch because of her headscarf. She's actually a really cool person. She ended up going on to, she still works with the EEOC and is a victim's rights advocate, and very cool. She's like well into her 30s now. But she says, I was a teenager who loved fashion and was eager to work at Abercrombie & Fitch. Observance of my faith should not have prevented me from getting a job. I'm glad that I stood up for my rights and happy that the EEOC was there for me. And then about the EEOC specifically, in the year 2015, they resolved 92,641 charges and secured more than $525 million for victims of discrimination in private sector and state and local government workplaces. So they're on it. They're keeping track. They're keeping count. This gentleman right here is Mike Jeffries. I mentioned him earlier. He was the CEO of Abercrombie & Fitch at the time of the EEOC case. I'm just going to read, this is from a press release from last October by the U.S. Attorney's Office. The snippet says, a 16-count indictment was unsealed today in federal court in Central Islip, charging former Abercrombie & Fitch CEO Mike Jeffries, along with a couple other men, with sex trafficking and engaging in interstate prostitution. The indictment alleges that between December of 2008 and March 2015, the gentleman used a combination of force, fraud, and coercion to traffic men while operating a prostitution enterprise. So again, this is the same man who came out and said that his fashion brand was intended for rich, fit, white kids. So that gives you sort of a general idea of the morals of the company based off of the actions and expressions of the people running the company. I just thought that was, and if you notice this case, his case of sex trafficking, it's all happening right in the crux of Samantha Aloff's case. So interesting. A couple questions that I have. Just in general, just straight up, do you think it would be possible for Abercrombie & Fitch to prove that allowing employees to wear a headscarf would, in fact, cause undue harm to the business? I'm thinking specifically in terms of when he's talking about his target audience, does he have the right to say the things that he did say? But also, what kind of like sector involvement, like financial, marketing, what would that look like in terms of arguing that case? And then do you think that Abercrombie & Fitch could reasonably assume that, again, based off of their target audience, that employing a young person wearing a headscarf in their stores, would that put the employee at risk of violence or discrimination by their targeted customer base, aka the all-American white person? Like, does it matter that the accommodation provided to her would be a visual accommodation, something that like their customers could see and make assumptions on the same way that their interviewer saw and made assumptions on? I don't know, something to think about. And then in terms of what was going on at the time in the world, I want to talk about just some general things happening, in the United States. So the Supreme Court reached the decision about EEOC v. Abercrombie & Fitch about 2 months after a white man killed a Muslim family of 3 over a parking dispute in North Carolina. So it was an ongoing parking dispute between a gentleman and another gentleman, and the one gentleman ended up killing the entire family of the other gentleman. They happen to be a Muslim family. Not saying it's related, not saying it's not related. And then it was made about a month after the protests in Baltimore over the death of Freddie Gray, who is a black man who died in police custody. That was a really big deal if you guys remember the riots that were happening in Baltimore. It was a really scary time, especially since it seemed like the police were not really getting any consequences. And then the decision was made about a month after a failed Islamist terrorist attack on the Curtis Culwell Center in Texas. They had been exhibiting drawn depictions of the Prophet Muhammad, and the Islamist extremists said that was incredibly disrespectful and offensive, and they openly attempted to attack the center in Texas. I don't think anyone was actually hurt. I think it was thwarted. But it was definitely attempted. And then this was actually also made around the time that the Rachel Dolezal scandal broke. I don't know if you remember, Rachel Dolezal was a white woman who was claiming to be a black woman. She was the president of the Spokane, Washington chapter of the NAACP. She was asked to step down. There was a lot of conversation about racial sensitivity and cultural appropriation going on at this time. I remember that was a lot of it was kicked off because of the Rachel Dolezal situation. The same month that the decision was made in 2015, a white supremacist, a boy named Dylan Roof, opened fire on an African-American church in Charleston, South Carolina. He killed 9 innocent black churchgoers purely because they were black. This is another event that sort of forced the United States to address racial sensitivity in the mainstream, except that this is in fact a mainstream problem, and it always has been. And then by December of 2015, this is when Donald Trump was the incoming president for the first time. He was calling for a complete ban on Muslims entering the United States following terrorist attacks by Islam extremists in Paris and San Bernardino. Islamic tensions in the United States were almost at an all-time high since 2001. And our incoming president, again at the time, and our current president, is a known Islamophobe. And then a couple of pop culture moments that I think were significant in terms of the ruling in favor of religious accommodations, especially, again, for the millionth time, Islamophobia, huge discussion in the United States at the moment. So the first one I want to talk about in 2015, Mariah Idrissi, she's a 23-year-old model who was the face of the fall 2015 collection for H&M. And she was a practicing Muslim, and she wore her hijab in the photo shoots for this campaign. This was the first time that the face of a major fashion campaign in the United States was wearing a hijab, and this was a pretty big deal. She was published in Vogue, Elle, Harper's Bazaar, really big name publications, and that was a huge deal because this was probably one of the first times that this was real couture culture, right? This is when kind of the first implication that hijabs are in fact high fashion, which is kind of cool, interesting to think about. There was a huge discrepancy in the way that headscarves, head coverings, hijabs were viewed in the United States. This was also right after an instance where a girl had been disallowed from entering a plane because she refused to take off her hijab, and they believed that it was some kind of safety concern. H&M made hijab high fashion, or at least acceptable in high fashion, if that makes sense. And then Amanda Saab, this woman here, she was a contestant on the popular television show MasterChef in 2015, also in 2015. She is a practicing Muslim, the child of Lebanese immigrants. And as you can see, she openly wore her headscarf on national television. And something that was really cool, she gave an interview afterwards talking about what it meant to her to get to wear the headscarf on television, and not just to get to do it, but to have it actually not be like a main focal point of the episode. They didn't bring it up, they didn't point it out, they weren't, they didn't make a big deal out of it. She just wore it, and it was what it was. And she basically said that meant a lot for her as a girl who grew up in the United States as a practicing Muslim, and how she didn't always feel as accepted as she had felt. And I think that's really cool and really applicable to the way the Supreme Court was thinking. And these are my references. Okay, thank you. Bye-bye.